They were quite informative, and both parties robustly engaged the evidence on record, interrogate its content, and refer to the necessary authorities, and which authorities the records reflect. I therefore owe my loyalty to your good selves, and thank you, two councils. And I now revert to my approach on the applicable legal principle. It is clear that the evidence any accused of 1977 appearance. Provisions of Section 60 Act reads, and I quote, an person who is in custody to the provision of subsection 6 be entitled to be released on bail at any stage preceding his or her conviction in respect of such an offense, if the court is satisfied that the interest of justice so permit. The right referred to in this section is further provided for in terms of Section 35, subsection 1F of the South African Constitution Act 108 of 1996. And the reason behind that is that the accused's freedom is interfered with, and the freedom of in terms of Section 12, subsection 1A of the Constitution Act 196. So in other words, on the first day that the accused appeared before this court, the accused was entitled to make an application for bail, and even on the second day that he appeared, there was no need for the matter to be postponed for further consultation because it was ripe for bail application to be advanced at that stage. The right referred to above for exercise by the applicant in this matter upon his or her first appearance in court. The applicant in this matter is facing Schedule 6 offences for which the provision of Section 60, subsection 11A of Act 51 of 1977 is applicable. The provision reads, and I quote, notwithstanding any provision of this Act where an accused is charged with an offence referred to in Schedule 6, the court shall order that the accused be detained in custody until he or she is dealt with in accordance with the law, unless the accused, having been given a reasonable opportunity to do so, adduces evidence which satisfy the court that exceptional circumstances exist which, in the interest of justice, permit his or her release. So, in other words, if I revert back to the address or the heads of argument by the state clearly indicated in his heads of argument that the onus is on the accused to prove that exceptional circumstances exist for him to be released, and this is further endorsed by the provisions that have just read into the report. And what are exceptional circumstances? Some may say exceptional circumstances is something simply different. There are, of course, varying degrees of exceptionality, unusualness, extraordinariness, remarkableness, peculiarity, or simply different. In State versus Skithekart, these are cases that may have been referred to by both the state and the defense counsel, and the reputation hereof by the court is in conclusion of the bail application. The court, Skithekart, 1998, Volume 2, SACR 707C at 713H to J. The court held that bail application is sui generis Sui generis in the sense that such an application can be done or be presented immediately on accused person's first appearance in court without waiting for the investigation to be done and finalized on the merits of the charge that is preferred against the accused. The application may be brought soon after the arrest. At that stage, all that may exist in a complaint is still to be investigated. The state is thus not obliged in its turn to produce evidence in the true sense. It is not bound by the same formality. The court may take into account of whatever information is placed before it in order to form what is essentially an opinion or value judgment of what an uncertain future holds. It must prognosticate. To this, it must essentially have regard to whatever is put up by the state in order to decide whether the accused has discharged the honors of showing that exceptional circumstances exist which in the interest of justice permit his release. In this case, the applicant presented his evidence through an affidavit, and in the case for the state versus Naju, is 2012, volume 2, SACR 395, ECP at 398, it was held that a bail applicant bore the honors. However, in this regard, filed an affidavit about his personal information, criticizes the strength of the state case against him. On the other hand, the state presented oral evidence in opposition of bail. The court accepted oral evidence of the state and rejected that of the applicant as contained in the affidavit on the basis that the state evidence was tested at the nation, whilst the applicant's evidence remained untested. In this case, the accused's evidence was on affidavit and therefore remained untested, and in all the offenses or charges referred to above, the applicant is alleged to have used a firearm and or a knife, in some instances clenched fist, and none of the instrument, by instrument this court is not referring to clenched fist, because as an accused person, obviously, he has his clenched fist as he's standing there. I'm referring to knives and firearm, and that's none of these items which I have referred to above were recovered. Despite the non-recovery of the weapons referred to in the charges, applicant insists to be released. The evidence of the state confirms that some of the offenses were committed by the accused when he was released on bail, even though a condition was imposed on him that he should not commit a Schedule 1 offense whilst on bail matter. And this condition that is referred to may clearly be found in the provision of Section 60, subsection 4A of the Criminal Procedure Act 51 of 1977 as amended. The applicant has a serious disregard for the law. The applicant was once called by the investigating officer. He took more than 5 hours to honor the request. But when he showed up, he was drinking liquor in front of an officer of the state, and there was liquor which the officer indicated was kept in the car, and therefore the officer requested for the interview that knows the applicant matter. In the attitude that has been shown by the applicant to an officer of the state. The applicant in this matter is an artist, musician, as indicated, or as Maburna. Further, the court, in considering whether the applicant is a good candidate to be released on bail, it must be satisfied that he is in compliance of the provision of Section 60, subsection 4, A to E of the Criminal Procedure Act 51 of 1977 as amended, and it provides, and I quote, "The interests of justice do not permit the release from detention of an accused where one or more of the following grounds are established," and this is a repetition. These grounds were also mentioned by the state in its address. "Where there is the likelihood that the accused, if he or she were released on bail, will endanger the safety of the public or any other person, or will commit a Schedule 1 offense." And there is evidence already on record that some of the offenses when the accused, which have been committed by the accused in this matter, he was already on bail on some of the matters for which a condition was imposed that he should not commit a Schedule 1 offense. Where there is a likelihood that if he were released on bail will attempt to evade trial, where there is a likelihood that the accused, if he or she were released on bail, will attempt to influence or intimidate witnesses or to conceal or destroy evidence, where there is a likelihood that the accused, if he or she were released on bail, will undermine or jeopardize the objective or proper functioning of the criminal justice system, including the bail system. Where in exceptional circumstances there is the likelihood that the release of the accused will disturb public security. In this case, evidence by the state confirmed that when he was released on bail in another matter, he committed a Schedule 1 offense. Whilst it may not be direct that the accused person may evade trial, the gravity of the offenses that the accused is facing influence him to may be tempted to take his life, thereby defeating the purpose for which administration. There is further evidence on record that the accused was involved in influencing the witnesses to have the charges withdrawn against him, and this evidence has been heard through the witness that has been called by the state. The accused victims were mostly his supporters, and as a well-known artist, they could not mistakenly identify him, so the identity more often appears accurate in the circumstances. This includes the witnesses that preferred charges against him. The accused victims were mostly his supporters, and the gigs that defense counsel referred to are held in public. Therefore, members of the public may not be safe in that as they approach him in order to greet him or whatever the circumstances, then such violent response happen to be unleashed by the applicant in the circumstances. As for the charges preferred against the accused, he more often used firearms or knives, and in some instances clenched fists. The applicant has a propensity to commit violent offenses. The weapon which the applicant used, save for his hands, were not recovered, and now the accused want to be released on bail. If indeed the applicant tends to commit Schedule 1 offense when released on bail, it can as well be assumed that he hid the said weapon referred to above in order to again use them upon his release. All the offenses against the applicant involves an element of violence. I need to indicate this to the applicant. I, for one, do not have anything against the applicant per se as a person. It is the conduct and personality of the applicant that caused the court to invoke the provisions which it has read into the record. It is the accused person himself that can do a personal introspection into himself to avoid finding himself in conflict with the law. And therefore, he will be able to propagate or progress with the career that he holds. No one can stand on his way. But the circumstances are the ones that have caused us to find gathered here, interpreting the provisions of the law in order to check whether exceptional circumstances as required in terms of Section 60, subsection 11A of the Criminal Procedure Act have been proven, so that the court may consider that the accused be released on bail in this regard. That is what the law provides. That is not what this court on its own interpret, but is the law that is applicable to everyone, including yourself as an applicant. Having said, the court further again referred to the submission by both counsels and the state. They were quite informative, very clear, and to the point. The court is further satisfied that the accused failed to discharge the honors that exceptional circumstances exist, which, if considered by this court, it will be in the interest of justice that accused be admitted to bail. And having said that, the application for bail for the accused is hereby refused.
Worship will agree on the date for further investigation, the 18th of February 2026.
Which date?
18th February 2026 in the new court airfield as the court is.
That being the role, this court now adjourns. Oh, sorry. My apologies. My apologies. Accused, I thought the state has already given the date. Accused, I'm informed by the state that this case has to be postponed. The date is the 18th of February 2026 for further investigation. The case is therefore so postponed and you will be in custody. Thank you. Court adjourns.
Lehlogonolo Shebe